Hey everyone, this is Zach, the broker of Zach Taylor Real Estate. So today I want to go over common contract mishaps. So doing the compliance for us, I am seeing a lot of deals come in, and I want our agents to write the best contracts and have the best protection from any legal liability and also protect their clients' best interests. And so I know we are not licensed attorneys. However, there are some things that I've been seeing with a lot of different deals that I know we can improve on. That way, we are not exposed to any legal liability, because all it takes is one client to get with an attorney to have them sue us, and then that hurts that agent's career or brand or reputation. So this video is truly coming from a place of wanting to help, wanting to keep you guys safe. So let's go through this contract. I've blocked out any identifying information. And if you can see here on line 3, though, there was 2 buyers originally listed, and the second name had a strike through the entire name. Now, strike-throughs can be used, however, 2 asterisks next to that statement. The first one is I always recommend using an amendment versus a strike-through. Amendment is clean, it is a separate form. It's just nice and easy. You can lay out the terms. You can say this person to be removed from the contract. All parties sign it. Nice and easy. Amendments will amend or change the original terms of the purchase and sale agreement. Now, if you use a strike-through, it's almost a shorthand for an amendment. But there are 2 big things with using strike-throughs properly. One is, yes, you strike through the whatever you're taking out of the contract, but all parties need to initial and date to acknowledge that they approve of this strike-through portion. So what that would look like is you have the strike-through already, and then you would see all parties initial and a date. That's what's missing from this as well. That way, everybody's on the same page. Now, the second caveat, if you use a strike-through, which I really don't recommend, is only strike through sections of the contract that have been added after the fact. So we would never strike through pre-written text, because then it's deemed we're practicing law and we could get in a lot of trouble. You can only strike through either things that we've added to the contract, or like if there's a text box somewhere, an agent has added info and they strike through, everybody initials the change. That's the only situation. So that's why I always recommend just go to amendment. It's nice and clean and easy. If you do a strike through, only use it for things that have been added to the contract, everybody dates and initials next to that change to make it enforceable. Now, if we go through the rest of this contract, let's clear that out. Okay, so we're scrolling through. There was a price there, good. Checkbox, good. To be paid by seller, good. Closing agency for buyer, closing agency for seller. This agent did a good job. Both of them were labeled. I've seen some contracts where only one is put here, like closing agency for buyer, but then the seller is left blank, or the seller has a TBD, and there's never an amendment in their file to show, well, who was the closing agency for the seller. So make sure this is fully filled out. Call the listing agent if you don't know who they want to use. Now, here's a very, very common thing I've been seeing a lot, and let's go ahead and improve on this, is financing contingency, loans to be obtained. So this is a cash deal. The buyer does not need a financing contingency. If that's the case, leave this section blank. Don't touch it. Don't put anything in here. You just check this, because this question right here, the loan shall be of the type selected below. Other cash is not a loan type. So leave this blank and just check this. Going through this contract, good. This was filled out properly. This is good. August 12th, good. Same thing on the deed. Both buyers were listed. The second one had a strike through. So all initials and dates next to that. Everything else is good. Okay, here's the biggest thing, and this is the whole reason I made this video. So if you made it this far, definitely pay attention to this. So time limit of the offer. This is the buyer submitting this offer and saying, Mr. and Mrs. Seller, you have until this date and time to accept my offer. Otherwise, this contract is terminated, and like nothing happens. We continue to move forward with our lives. Nothing happens because it wasn't accepted. But you have until 6 p.m. on the 7th day of June. That was the original. There's a strike through here, and it marks the 8th. So the buyer signed on the 6th. That is okay. Then they sent it over and said you have till the 7th at 6 p.m. The seller signed on the 8th. Now with this strike through, we don't know who did this. Did the buyer do this? Did the seller do this? Did the seller call and say, hey, Mr. or Mrs. Buyer, I'm out of the country. I'll be back on the 8th. That's when I can sign it. The buyer could have agreed to that, but we don't know because there's not initials and dates next to this change. So that's the big thing. Or if the buyer sent this over and the seller did this themselves, well, now they're signing a contract that isn't valid anymore. It expired. So we need to know that everybody approved of this change, that it has been signed within the time limit of the offer. It was signed when the contract was still valid to be accepted. Right now, it expired, and this is what we're dealing with. The second thing with this is, notice here, this is all a flattened PDF image. This is all flattened, but this is new. So this means this document was downloaded onto a computer, uploaded in .loop, and then this was added after the fact. So now this has been changed, and that definitely is a big legal liability. We are changing the terms. We do not have signatures showing everybody approved of this addition. So that is not good. If we move on to the next page, and it's also, there's no acknowledgement of receipt. So let's go through confirmation of agency status. So this was a very unique situation. You don't see this all this time, but it's a good addition to the common contract mishaps. So this seller hired a flat fee company to list their property only. So they, on the listing, even said, contact the seller for showings, send them the offers. This is truly just a listing only. So on this confirmation of agency, the licensee name was put here. The seller name is blank. And again, we have this flattened PDF image, and then this checkbox was added after the fact. So this original document had a licensee name signed by the seller, but nothing checked. And we also know with this check mark, seller is underrepresented. The seller does have some sort of relationship with the agent. They hired an agent to list the property. So they are serving in some sort of capacity. So is that a transaction broker facilitator, or is that an agent for the seller? Maybe they're not the designated agent, but maybe they're a facilitator or agent for the seller. So we need to figure out what that is, because there isn't a licensed agent that listed the property. Even if it's MLS only, we need to reach out to them, and we need to figure out what role they're serving and have them sign off on this as well. So these are just common things I've been seeing. I thought this contract was a really good example of how we can better improve. This truly comes from just informational purposes. This agent is awesome. So we're just trying to get better and better each and every day. If you guys have any questions with your contracts, definitely always reach out to me, because it not only falls on you guys if something goes wrong, it always falls on me. So let's work together. Let's improve our contract skills. If you have any questions, always reach out, and I will see you guys next time.